keep it tight. Hold my baby squid, keep them out of sight. Talking about my life, government, stay away. If you drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. Mama to my baby, protecting with my no government intrusion. I control my life.
Hey guys, it's Squid. Welcome back to my channel. How is everybody doing on this Wednesday? Oh my goodness, I wasn't sure if I was going to go live. And I have like 3 or 4 different things that I want to go live about. But I was looking up some cases, and my Hannah Dugan, the judge gone rogue, on the 7th, the judge filed a 37-page document. The judge filed a 37-page document. Let that one sink in for a second. Okay, now that we are all clear on this is a federal case. This is about the circuit court judge in Wisconsin that decided to let a quote-unquote undocumented immigrant, illegal alien, whatever. I am not getting into the what you want to fucking call it about the status. If you have overstayed your visa or you have not shown up for a court date, I don't care exactly what you want to call it. You're not supposed to be here. And if you go to any other country and you overstay your visa, they will kick you out. But apparently we are the only country who cannot follow immigration laws that are on our books. And I always tell people, if you don't like the immigration laws, stop having people break the laws and tell your fucking congressmen to do their damn jobs and change the law, because that's what we're sending them there for, right? No, we're sending them there to make TikToks so they seem like normal people. Anyway, hope everybody is doing well today. Robert Ward, thank you for being a member for 1 month. Hello all, can't stay long. So we are going to get into this 37-page document that this judge filed. And I've been waiting for updates because there's been like motions for amicus briefs from both sides, prospective amicus briefs from good sides. You know. I saw a video this morning, and I want to make a collection. Like, I have collections of, because all I do on Facebook, people that I have to laugh at the people who are like, she said she doesn't have Facebook. No, I said I don't use Facebook. I don't post anything worthwhile. I literally scroll through reels. I keep in touch with my family. That's thousands of miles away. I keep in touch with my friends that I made in the military who are thousands of miles away. And I scroll through reels and hit share. Or when I see one that says, hey, Buttercup, like I saw one this morning that said, on days you don't want to work out. And then all of a sudden it cut to David Goggins and it said, suck it the fuck up, or like something like that. And I'm like, okay, this is me today. Like, I have to share this because this is me. I don't want to do anything today. I didn't go to sleep until almost 1 o'clock in the morning. So this is Judge Hannah Dugan. She is a circuit court judge in Milwaukee, which is my home count. Like, I was born in the Milwaukee, Waukesha, Milwaukee, Waukesha counties. If you're from there, like, if you know, you know. But this is going to be from Magistrate Judge Nancy. Oh, crap. I can't remember her name already. I feel bad. Nancy Joseph. Spawn Trooper sneaks in, lets the other mods know he's gonna get his own back on Squid. Never undo the screen sniping. And I just got a message, and I'm going to read it. It says, check my comment. How dare you ignore the King of Wales? Self-proclaimed. You're a king of something. I'm not really sure what it is yet, or if it's appropriate to say on YouTube, but you're the king of something. But we're gonna get into this. Spawn Trooper, you pick on me all the time, and I pick on you back. It's just what we do. And Unhung Hero, thank you for the 20 gifted Squid Pro Quo memberships, turning the chat green. Hey, Flash fan, I told you I was going to talk about that other case today, but then I started checking Pacer, and the judge in the Hannah Dugan case filed a 37-page document. So, and it kind of sums up the case, but it also has a couple of orders in there. So we are going to King of Horse. There's one. And sorry, I have gym hair. I took a shower when I got home, but I did not wash my hair because it's not worth it. Let's open this document. Come on, lady. Do your damn job. I did save it because this is like $3 that I can never get. Well, I don't want to pay for again. Oh my goodness. Alrighty. Let's present share screen. Whoop. Window. Alrighty. Let's get into this one. And I made a special. There we go. So y'all can see it. But it's not as. There we go. I like that one better. I don't know. I like, for some reason, it's basic, but I like StreamYard's ability to move around my stuff a lot better than Streamlabs. I know it's basic, but damn, it's better. All right, this is Eastern District Court of Eastern District of Wisconsin, and you can see that each district, I don't really like the way this is laid out and the layouts and the requirements that the Eastern District of Wisconsin has. This reminds me of like a 1980s typewriter. Florida is so much easier to read. So so it's a good thing. Yeah, and we're going to, because I've done the initial complaint and other things like that, I'm going to kind of skip some of the things that I've already read. However, for those of you who haven't joined me for that, this is not the Hales case. This is Hannah Dugan, the judge gone crazy in Wisconsin. So this is completely different jurisdiction, completely different issue. Hey, Malin. All right. And sorry, I just got something in my eyes. All right. U.S. v. Hannah Dugan. Report and recommendation on defendant's motion to dismiss. 37 pages. I have not seen a judge write 37 pages in a while. On May 13th, 25, a grand jury sitting in the Eastern District of Wisconsin returned a 2-count indictment against Milwaukee County Circuit Court Judge Hannah Dugan. Dugan is charged in count 1 with knowingly concealing a person for whose arrest warrant and process had been issued in violation of 18 U.S. Code 1071. Charged in count 2 with obstruction of United States Department of Homeland Security's removal proceedings, violation of 18 U.S. Code 1505. Dugan was arraigned on these charges and entered a plea of not guilty. Jury trial before the Honorable Judge Lynn Edelman will be scheduled after a resolution of pretrial motions. Dugan moves to dismiss the indictment under Federal Rules of Criminal Procedure 12B on the grounds that she, as a judge, is immune from criminal prosecution. Sorry, this makes me laugh because fucking judicial immunity pisses me off. If you want to know how to make Squid go from 0 to pissed in like 2.5 seconds, mention judicial immunity. No, because it's federal. But I do have the minutes from, like, the hearings and stuff. The little girl is... That's how she feels about this. Wisconsin is pretty lively for courts from the sounds of it. Forgive butchered stallion. It's a love your 90s eyebrows. This is I put my CC cream and I don't ever do my eyebrows because when you figure out that answer, Malin, you let me know because I don't know. Which is one of the reasons that I enjoy going through PACER documents, because if we don't go through PACER documents, none of this shit gets reported except by the mainstream media. And we all know how reliable those mofos are. So, Squid is my heroine. Hello. I'm going to try to read this with a... Yeah. Dugan moves to dismiss the indictment under Federal Rules of Criminal Procedure 12B on the grounds that she, as a judge, is immune from criminal prosecution for judicial acts, that her prosecution violates the limits of federal power under the 10th Amendment, and that the indictment could be dismissed under the canon of constitutional avoidance. Additionally, two parties seek leave to amend or to file amicus curiae briefs, document 25 and 32. One is from a bunch of retired judges, shocker there, and the other one I have is from U.S. Center for American Rights is the other one. So they're basically opposing. Yeah, the entire defense of judiciary immunity was a long shot defense. And judicial immunity is meant for people meant for judges so that defendants who are in their courtroom can't seek retribution. Not for this. You hiding somebody or saying they can leave out a side door to avoid people who you know are there to arrest them is not a judicial act. That is a shady fuck act. Sounds like Lynette is there. No, Flashman, you don't make me mad by talking about the Navy. I talk bad about the Navy all the time. What you make me mad is when you call me Army. No, your guess is in relation to the cameras in federal court, your question is as good. Honestly, I don't really have an answer for that. It's up. I don't know. In regards to the states, each state is like a separate country. So even though we all fall under, it's like most of Europe falling under the European Union, but each being their own country. It's kind of not exactly the same thing, but it's as close of a shot that I can get. Florida and Nevada and California and Wisconsin and Minnesota are all completely different and have completely different sets of laws. However, it's so some states will allow it, some states won't, but federal is just never does. So we have to rely on the mainstream media or whoever's in the courtroom. Usually it's only mainstream media. And then we get stuck with whatever they say. Yeah, not for acts of criminality. Yeah. All right. The government opposes Dugan's motion, document 28, and objects to the filing of both amicus briefs. Interesting. For the reasons explained below, I recommend that Dugan's motion to dismiss be denied. I mean, whatever happens, and I am in a Facebook group called Wisconsin Conservatives. I've been there in that group for days. For years. I don't always agree with people on both sides, but I'm in groups so I can hear. And they're like, I hope she gets jail. I hope she gets jail. I made multiple comments of like, guys, wishful thinking, but I literally read the documents. And this is why I read the documents, because this is what the shit that the media won't tell you. The government is not seeking jail time. Unfortunately. They're not seeking confinement, which kind of sucks, but at the same time, you know, But whatever you think of this case, and however you want to do this, as far as like, I am pleased to say, and this is not me being misogynist or anything or whatever, anti-feminism, but for a female judge, especially a female judge in Wisconsin, I know she's federal, but technically she's still a Wisconsin. She's still from Wisconsin. She still practices or, does her job in Wisconsin. It's a liberal shithole. Sorry, guys. Sorry, my people and my family who live there. I love you dearly, but I am not upset that I left. I do miss the sports, but I am not upset that I left. Angel, do you want to come here? Come here. Do you want a banana? Go get it. Go get it. You know where it's at. It's on the counter. Don't smash it on the way in here, though. We have a hard time of we have a death grip on things. The fact that her motion to dismiss was denied makes me happy. Like, whatever happens with this case, the fact that this judge is actually having to go to court makes me happy. Oy. Judge Darrow is god awful. I hate her. Like, she's horrible. Ugh. No, I hate Judge Darrow. She was easy on him in that case because she wanted to run for state Supreme Court and it epically failed. I have to go get she is apparently not happy with whatever she's doing in the kitchen. So yeah, Squid don't like her. I think she was too easy on Daryl Brooks. I understand the pro se defendant, but I think she lost whatever female lady balls she had. I will be right back, guys. Get a drink.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals they take us higher. The night's young, it has just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, every shot from the top. We're gonna be two hearts running wild. Now the morning is the afternoon. We lay awake in bed. The glass so loud as the hours pass. We're gonna do it all again. We wanna chase the night.
Hey guys, sorry about that. Epic mom fail. I told her to get a banana. Apparently, she either ate the last one or her dad took it or somebody. We didn't have it. And I can't give her a banana that we don't have. So when I literally sent her in the kitchen to go get a banana, she couldn't get it because we didn't have any. Mom fail. Yeah. Baby Squid Banana Fund needs replenishing. Oh my goodness. Hey, Joseph. Yeah, Broken Baker also doesn't like Darrow. He said she talks too much. Yeah, like, I know I talk a lot. And I know that I teach when I try to explain things because I have a toddler. I have a background in OT. So when I do things, I explain to people why I'm doing it. It was always a thing like, hey, when I'm doing something, makes the patient more comfortable if you explain to them what the hell you're doing. However, she didn't need to explain 99% of the shit that she did. She had too many banana yogurts already, to the point where her next diaper is going to be an atomic bomb, if you know what I mean. And you can only have so many yogurts before you're like, Oh yeah, I did. It's handled. She's got a snack, but we are good. All right, but the request for leave to file the amicus briefs are granted. Background, the indictment, I read on my stream, but we will kind of give a brief rundown. April 18th, EFR is the person in question. Dugan knowingly concealed EFR, a person whose arrest warrant and process had been issued under the provisions of law under the United States to prevent the discovery and arrest of EFR after notice and knowledge of the fact that a warrant and process had been issued for the apprehension of him in violation of 18 U.S. Code 1071. On April 18th, Dugan did corruptly endeavor to influence, obstruct, and impede the due proper administration of law under which a pending proceeding was being had before a department and agency of the U.S. She interfered with the two agents that were there by telling them they couldn't do what they were doing with an administrative warrant. They had to go see her boss. I can't remember the person's name. However, knowing he was out to lunch, literally out to lunch, not, cognitively out to lunch, and that they would have to wait, giving that person time to leave. Namely, the administrative arrest of EFR for purposes of removal proceedings conducted by the U.S. Department of Homeland Security by committing affirmative acts to assist EFR to evade arrest, including confronting members of ICE and falsely telling them they needed a judicial warrant to effectuate the arrest. Upon learning that they had an administrative warrant directing members of ICE task force to leave the location of the planned arrest, a public hallway outside of her courtroom in the Milwaukee County Courthouse, and go to the Chief Judge's office. Addressing EFR's Milwaukee County Circuit Court criminal case off the record. Off the record. What judge does shit off the record? Makes me so angry, which is one of the reasons I'm talking about this, because I don't like corruption on any level. Any level. And from anybody. I hate hypocrisy. I hate liars. I hate people who are supposed to enforce the law and allow people to break it right in front of them. It's bad. Directing EFR and his counsel to exit courtroom 615 through a non-public jury door and advising EFR's counsel that EFR could appear by Zoom for his next court date in violation of 18 U.S. Code 1505. Legal standard. Federal Rule of Criminal Procedure 12b1 provides that a party may raise pretrial motion, any defense, objection, or request that the court can determine without a trial on the merits. When deciding a motion to dismiss a criminal indictment, the court assumes the indictment's factual allegations are true and must view all the facts in light most favorable to the government. United States v. Calhoun, Northern District of Illinois, 2024, citing U.S. v. Yashar, 7th Circuit, 1999. Federal rules of criminal procedure, however, do not provide a mechanism analogous to the motion for summary judgment in the Federal Rules of Civil Procedure, U.S. v. Abrahamson, Northern District of Illinois, 2023. Thus, if the defense raised a factual dispute that is inextricably intertwined, say that one 10 times fast. I mean, off-the-record stuff is normal. They sometimes have chamber meetings. Off-the-record stuff with the defendant, not counsel. Defendant. In regards to his case. Like, it's one thing to talk to the counsel for both sides in chambers. But with the defendant present, you're discussing his case with him present off the record. No bueno, sir. No bueno. She's done eating her snack, so let's see how this one goes. With an inextricably intertwined with a defendant's potential culpability, a judge cannot resolve the dispute on a 12B motion. Citing U.S. v. Sampson, 2nd District, 2D Circuit, 2018. This 2nd Circuit, I'm assuming that was supposed to say 2nd Circuit, 2018. The judge needs to proofread. But also, this judge has a love of big words. Oh, she did. She claimed judicial immunity. That's her defense, is judicial immunity. Yep. Analysis. Dugan moves to dismiss the indictment on 3 grounds. First, she argues that a state court judge acting within the scope of her judicial duties, prosecution is barred by judicial immunity. Second, and I'm going to skip that because we're getting into it. Judicial immunity, because the parties differ in their views on the applicable law, it is instructive to begin with a survey of the law on judicial immunity before turning to Dugan's arguments and to the applicable law to this case. This judge likes to hear herself talk. History of judicial immunity in civil lawsuits. This is not a civil lawsuit, though. Okay, whatever. Judicial immunity is a long recognized concept dating back over 400 years to English common law, insulating the judiciary from civil liability. See Jeffrey M. Shaman, Judicial Immunity from Civil and Criminal Liability, 1990, citing Floyd v. Barker. Star Chamber, 1607. Talk about a throwback. Prior to the creation of the right to appeal, a losing litigant would seek nullification of a false judgment and a fine against a judge who rendered it. However, once an appeal system was put into place, giving a dissatisfied litigant an avenue for redress, the concept of judicial immunity arose and was gradually accepted under common law. Early years. Seminal case Floyd v. Barker, decided by Lord Coke in 1607. Damn. Addressed the question of whether a judge presiding over a murder trial could be prosecuted in another court for criminal conspiracy. See note, judicial immunity at the second founding, a new perspective on statute 1983, 136 Harvard Law Review, revisions 1456 and 1464, 2023. Lord Coke concluded that judges were immune from such prosecution, stating a judge for anything done by him as a judge, by the authority which the king hath committed to him, and as sitting in the seat of the king, concerning his justice, shall not be drawn in question before any other judge. In other words, Lord Coke pronounced a rule of absolute immunity for judicial acts. Floyd is also important for articulating the first time when what are now considered some of the modern policies that underlie the doctrine of judicial immunity. This is a history lesson. I'm learning a lot today. What about y'all? I mean, I knew what judicial immunity was, but I didn't realize the 400 years of history. Like, I'm kind of glad you held off on the Ohio case. I have a feeling I'm going to have to control my anger with that guy. I have issues remembering the presumption of innocence when it comes to that guy. Yeah, the Ohio case is going to be a that might have to be a Saturday night when I have wine. That's a trigger warning case. Just looking at some of that stuff that you sent me, I'm like, oh, this is going to have to be a yeah. Oh yeah. She just keeps, can you hear her in the background? She just keeps going, mama, mama, mama. And every time I look over at her, she's just looking all cute, sucking her thumb. Why did I have to give birth to the cutest human being on the planet? Like, a king didn't appoint her to the bench on Parliament's behalf, unfortunately. You know, just checking. I'm getting like 100 notifications from Discord, and I'm like, I don't know if any of them are actually like important. Yeah, the thing is I have my settings so that, can you turn off the light, please? No. Oh, I hate my there we go. Why doesn't I have my mic to set up to reduce background noise, but apparently it didn't save. Yeah, it's just she's just mama to be saying the name of her favorite person. Girl, that's harsh lighting on my eyes. Sorry, guys. You know, mama first, YouTuber second. Crazy girl. Floyd is also important for articulating the first time and are now considered some of the modern policies that underlie the doctrine of judicial immunity. Judicial immunity serves the following purposes according to Lord Coke. It ensures the finality of judgments, protects judicial independence. It avoids continual attacks upon judges who may be sincere in their conduct. Here's the problem. Here's the problem I see in 2025. Sincerity. It protects the system of justice from falling into disrepute. The first major application of judicial immunity by the U.S. Supreme Court occurred in Randall v. Brigham, 1868. In Randall, an attorney was accused of obtaining an agreement from a client that was unconscionable and extortionate. Girl, your hair is crunchy. You need a bath. Therefore, grossly unprofessional, and was removed from his office as an attorney at law. In response, the attorney sued the presiding judge for unlawful removal. And the court, citing Floyd, stated it's a general principle of applicable to all judicial officers that they are not liable to a civil action for any judicial act within their jurisdiction. The court left open a possible exception to this absolute immunity, however, where the acts in excess of jurisdiction are done maliciously. There's the key word, or corruptly. Yeah, tar and feathers date back to 1607. Can we argue that case, or argue that case to use that as well? I mean, I'm all good for, yeah. I'm all good for a little public shaming too, because, you know. 3 years later in Bradley v. Fisher, 1871, the court made clear that civil judicial immunity applies even for malicious or corrupt acts. civil. In Bradley, Attorney Joseph Bradley was a member of the bar of the Supreme Court in the District of Columbia, and Judge George Fisher was one of the justices of that court. While representing a party during the trial before Judge Fisher, Attorney Bradley alleged accosted the judge in a rude and insulting manner. Well, in 2025, just saying please be quiet is apparently rude and insulting to people. After Judge Fisher effectively disbarred Bradley for his behavior, Bradley sued Judge Fisher for monetary damages. Invoking Floyd, the court... Angel. What? Angel. Here. Girl, you are 8 kinds of messy. You are 8 kinds of messy. Here. Hey. Hey. Beautiful. Hey, Roy, how are you? Yes. Please feel free to help Squid pay down her Pacer bill if you can. She appreciates every one of you. I do. Even the people who hate watch, because you give me ad revenue, so thank you. I appreciate every single one of you. I really do. Well, if asking to be quiet doesn't work, shut the fuck up works. Well, you know. Invoking Floyd, the court noted the principle which exempts judges of courts of superior or general authority from liability in a civil action for acts done by them in exercise of their judicial function. This is civil, though. I'm still wondering where she's going with this, because this is civil. Hiding somebody from aiding and abetting a criminal is not civil. I sometimes I wonder. Has been the settled doctrine of the English courts for many centuries and has never been denied in the courts of this country. The court further stated, the exemption of judges from civil liability cannot be affected by the motives which their judicial acts were performed. The purity of their motives cannot in this way be subject of judicial inquiry. Thus, even though Bradley accused Judge Fisher wantonly, corruptly, arbitrarily, and oppressively intending to remove Bradley from his office as an attorney at law, the court concluded that judges were not liable in civil actions for their judicial acts, even when such acts were taken in excess of their jurisdiction. Modern era. Pearson v. Ray, 1967. Court granted certiorari. I always struggle with this freaking word, so we're just going to skip over it because it's there. I screw it up every time. To consider whether a local judge was liable for damages under 42 U.S. Code 1983 for an unconstitutional conviction. Section 1983 allows individuals to civilly sue state actors for depriving them of their rights, privileges, and or immunities secured by the Constitution. 42 U.S. Code 1983. The plaintiffs were members of the group of white and African-American Episcopal clergymen who attempted to use segregated facilities at an interstate bus terminal. They sued local police officers and municipal police jurisdictions for false imprisonment after they were convicted of disturbing the peace. The plaintiffs alleged that the judge's findings of guilt and sentences were based on racial discrimination. The Pearson court had no difficulty finding that the judge was immune from liability for damages for his role in the convictions, as few doctrines were more solidly established at common law than the immunity of judges from liability for damages for acts committed within their jurisdiction. Citing Bradley in support, the court stated that immunity applies even when the judge is accused of acting maliciously and corruptly, and it is not for the protection or benefit of malicious or corrupt judge, but for the benefit of the public, whose interest it is that the judges should be at the liberty to exercise their functions with independence and without fear of consequences. Here's the problem, though. This is just my personal opinion. when judges are actually doing their damn jobs, it's not as big of a deal. However, in 2025, all I see is judges who are politically active, even all the way up to the Supreme Court. Although yesterday you did have the 8th, you had an 8-1. When even Sotomayor doesn't agree with Ketanji Brown Jackson, you're like, huh? Like you that's got to be embarrassing. However, when judges are now looked at by who appointed them and not what fucking job they're doing, there's a problem there. And I feel like now judicial immunity is not the same as it was even 50 years ago. Judicial immunity is like, I don't know how to word that appropriately, but y'all know what I mean. Judicial immunity is now more about, or judges are not, Flash fan, I'm positive that Judge Arthur is a Republican. I'm almost positive just because of the fact that it's Mississippi. Yeah. And a few other behaviors that he exhibited, like not taking shit, and being extremely fair to both sides. And even when he was talking to the Carly Gregg, he was talking to her like he was her dad. Like, hey, no, he's actually live on his own channel. Why? What's up? He's doing some gaming today. I'm not sure. When I talked to him on the phone earlier, he didn't talk about what he was going to stream about today. All right. I have a big problem with this, though, in the sense of like judicial immunity is not what it was back then, because I think judges back in the day, for as many problems as this country had back in the day, we're law and order. Our laws might not have been good, if you know what I mean. Like, we're what we're getting at. Not gonna go down that road, but I'm not. I'll talk to him. I doubt it, but I don't know. Sometimes you know how easy it is to accidentally ban somebody and not even realize it. It's happened to me where I've looked at my ban list and been like, how'd that person get there? So I'll ask him about it. Most judges back in the day were former military. Yeah. Banned. Oh my god. I used to ban people all the freaking time when I mod from my phone. Oh god. Shit. It happened all the time. If you click on the wrong thing, like there's these 3 little dots here, and all I have to say is like ban user in their comments. All it takes is a slip of the thumb, and it's like, oh crap. And if you accidentally do it, not realize that you do it, and then you don't realize that you do it, so you don't tell the creator doesn't go and look, because it's not like a list you check every day. So Captain Kurt, we're not banning anybody. We're not banning anybody. The 3 people who are banned from this channel, at least 2 of them know they're banned from this channel. Yeah. Flash fan. I accidentally banned someone here by accident when I first became a mod. Yeah, it happens. It's so, and y'all don't realize how, if you're not a mod anywhere, congratulations. You don't realize how simple it is to do. It's so easy to screw up. It happens to me all the time. But if the creator is busy And a lot of times when Spawn's on a roll, he's on a roll and he doesn't pay attention to chat. So he won't see that like somebody got timed out. Sometimes it'll all of a sudden show up or it'll be on his ban list. And if you don't know, you don't know. Yeah, but that's because you're a butthead. Accidentally. Tammy, I'm just going to write it down so I don't forget because y'all know. I'll get sidetracked. No. And with the amount of Tammys that come in here, I love you all. Well, except for one of you. But I love every single one of you, but I'll forget which one. Also, has anybody seen Tammy Fayette lately? Is she doing okay? I have not seen her what feels like forever. It might have been a day, it might have been a week. Yeah, I know. I'm a butthead. But see, this is the kind of relationship and friendship that we have. Like, I can call you a butthead and you just call me one back. Whereas some people are like, you called him a butthead. Why are you being so mean to your mods? Why are you being so mean to Captain Kern? Captain Kern knows I'm not. Well, and that's good for you, and I'm so happy for you. I have to do. It's sometimes when I'm modding from my phone. Vices used to ban people ban people when he'd fall asleep modding, and he'd so it happens. Yeah, I've accidentally banned someone. Yeah, it happens. If it hasn't happened, I'm happy for you. Like, there's no hate, no shame. Like, I'm truly, because it happens to me more than once. And I'm usually like writing the creator when I realize it. And I'm like, oh my God, I'm sorry. Didn't mean to do that. My bad. Sorry. Or I'll drop my phone or Baby Squid will grab it and, I don't know. Oh, but I am Nick. That's awesome. You're a better person than I am because I'm bad. On my computer, I don't do it. On my iPad, I don't do it. But the convenience of this little shit is what does it. Yeah, it's all right, getting back to this, because we are on page 7, and I got about 50 minutes left. So we might have to break this up into 2 sections. Yes, please continue. Squirrel moment over. Shortly over a decade later, the Supreme Court again addressed judicial immunity in Stump v. Sparkman, 1978. In Stump, the mother of a 15-year-old girl presented a document entitled Petition to have tubal litigation performed on minor indemnity agreement. That's tubal ligation. It's a medical procedure. Judge Harold Stump for signature. Judge Stump approved the petition despite the fact that the petition was not given a docket number, was not placed on a file with the clerk's office, and was approved in an ex parte proceeding without notice to the minor, without a hearing, without the appointment of a guardian ad litem. The minor was sterilized without her knowledge, under the pretext of having an appendectomy. That's some shady shit right there. After learning the true nature of the surgery years later, the daughter sued multiple parties, including her mother and Judge Stump, for violation of her constitutional rights. Yeah, modding on phones is also super dangerous. I also don't like that I can't tag people. It sucks. We need little Squid in here to understand. She's right there. She's like 10 feet from me, sitting on the chair on the other side of the room next to her dad's computer. So she's here, and you'll hear her scream and try to talk over me. The court concluded Judge Stump was immune from civil liability. The court reiterated that the necessary inquiry in determining immunity was whether, at the time, the judge took the challenged action, he had jurisdiction over the subject matter before him. As a judge will not be deprived of immunity because the action he took was in error or was done maliciously or was in excess of his authority. See, and that's the problem I have with judicial immunity. The malicious part. If you make a mistake as a judge, like, shit happens. Like, people make mistakes. And we have to understand that despite being a judge, nobody's perfect. And that's kind of my part of my problem with some people that have a problem with the judge in the case that will remain nameless right now. We'll talk about it tomorrow because there are new documents. However, no one is perfect. But it's this malicious part right here that I have problems with. Because when you do something malicious and then hide behind judicial immunity, that's my problem. Making mistakes, shit happens. We all make mistakes. I make them on a daily basis. Y'all watch half of my mistakes when I show a document that I wasn't meaning to show. That I was going to talk about the next day, and I had it up and I accidentally shared the wrong document. Mistakes happen all the time. I can't read something. I made a mistake. I skip a paragraph. I reread a sentence. But like, I didn't do any of that maliciously. You don't do the malicious part is what I have a problem with. He will be subject to liability only when he has acted in the clear absence of all jurisdiction. The court found that because the court over which Judge Stump presided was one of general jurisdiction, neither the procedural errors he may have committed nor the lack of specific statute authorizing his approval of the petition in question made him liable. A lack of a specific statute, that right there should be his whole job. In order to do something, you need a statute. And this is going into my rabbit hole of judicial immunity. And this is part of the reason I'm covering this case is because I hate judicial immunity. Absolutely hate it. Hate it. Like, oh, CH, you're welcome. I am only talking about that case Monday, Wednesday, and Friday. That way everybody knows when documents are going to be read. And if you see me talking about something or you see me going live or releasing a video, it won't be about that. It may reference it for various like comparisons, but it will not be a blanket what the hell stream. But then you know when to expect, like, it's saving me headaches of people asking me, when are you going to read this document? Have you heard about this? It's like Monday, Wednesday, Friday. Monday, Wednesday, Friday. And then we're all clear. It stays clear in my brain and the brain fog doesn't get the best of me. Yeah, there needs to be an avenue to hold malicious action by a judge accountable. There should be oversight. And that's the thing. Maybe, just maybe, and it's not that I hate Judge Dugan. I don't hate I lied. I do hate a couple people, but none of them are involved in this particular case. I don't like what she did. I think what she did is shady, but you need to be held accountable. And maybe that this will set a precedent. I look at cases that I'm hoping will set precedent. And this is one that I hope will set a precedent for the future. If it's malicious, that should be criminal. And that's what, yeah. And that's one of the reasons that it's weird. Like I'm kind of enjoying the background on judicial immunity and the education, because it's one thing to like Google something and read a random summary from some law review or some website or some lawyer's office that wrote an article. But it's another thing to see it actually from a magistrate judge in citing case law, citing specific issues. But the problem that And I'm wondering if future down the road she's going to mention the fact that all of this doesn't matter because it's criminal charges and not civil. I don't hate the Rittenhouse judge. I think that he was, I don't know. Judge Schroeder is a nice guy. I think Judge Schroeder would be the type that I could go to like a Brewers game with, or like have a beer with, or like sit back and tell like sea stories or something with. But like his inconsistency between Rittenhouse and, oh my God, that other case. Oh shoot, I'm sorry, I'm coming up with a brain fog. It's the one where he was convicted, and I believe he was wrongly convicted of unaliving his girlfriend. Yeah, Zachariah Anderson. Thank you, Flash fan. I was having a blank spot. The inconsistencies between the two cases, just watching him and his decision making, like, yeah. Mm-mm. Hey, Jinx. Hi. Good to see you. And hey, Mom. All right. Nor the lack of a specific statute authorizing his approval of the petition in question made him liable. Nor did the informality of the proceedings render Judge Stump's actions non-judicial. Rather, the factors determining whether a judge's act is judicial relate to the nature of the act itself and the expectations of the parties, whether it is a function normally performed by a judge, and whether the parties dealt with the judge in his judicial capacity. And in this case, the court concluded that because Judge Stump performed the type of act normally performed only by judges, and did so in his capacity as a circuit court judge, he was immune from civil liability, despite the unfairness to litigants that sometimes results. 2 years later, in Dennis v. Sparks in 1980, the court was again faced with the question of judicial immunity for damages under 1983. In Dennis, a state court judge enjoined the production of minerals from certain oil leases owned by the plaintiffs. The appellate court subsequently dissolved the injunction as having been illegally issued. The plaintiffs sued the judge for monetary damages under Statute 1983, alleging that the injunction had been corruptly issued as a result of a conspiracy between the judge and other defendants to deprive the plaintiffs of their property, i.e. 2 years of oil production, without due process of law. I mean, back in 1980, it was a lot cheaper than it is now, obviously, but you know. The Court of Appeals upheld the district court's finding that the judge was immune from liability under 1983, whether or not the injunction was issued as a result of a corrupt conspiracy. The Supreme Court affirmed that stating again that the court had consistently adhered to the rule that judges defending against Statute 1983 actions enjoy absolute immunity from damages liability for acts performed in their judicial capacities. However, while the judge was immune from suit, the court concluded that the conspiring parties could still be held liable under Statute 1983. Here's the thing. This is once again civil. Dugan's being charged criminally. I mean, there's a lot. The judge's co-conspirators argued that if the case went to trial, the charge of conspiracy and judicial corruption will necessarily be aired and decided, the consequence being that the judge, though not a party and immune from liability, will be heavily involved, very likely as a witness, forced to testify and defend his judicial conduct. Oh, the irony in that statement. I'd also like to see a rule where if a judge is overturned 3 times appeal in, say, a 5-year period, they're removed from the bench and disqualified from ever being considered again. I don't disagree with that. I think that judges need to be held, and lawyers need to be held to a higher standard, but there's a thing about being held to a higher standard and people actually following through on the consequences of actions. Because it's all well and good to say, oh, they should be held to higher standards, but then put your money where your mouth is, mofos. Oh, she just locked us in. Girl, your hair's crunchy. She was sweaty and dirty today, and she needs a bath tonight. Girl, your hair's crunchy. Oh my goodness. Yeah. What's up, Angel? You want it up here? Oh, she wants it up there. Okay, she wants my cup on the table. All right, this is definitely going to have to be a two-parter. Because we are only on page 9 of 37. The court concluded, however, there was no constitutionally based privilege for immunizing judges by being required to testify about their judicial conduct in third-party litigation, nor has any demonstration been made that historically the doctrine of judicial immunity not only protected the judge from liability, but also excused him from responding as a witness when his co-conspirators are sued. The court concluded that judicial immunity was not designed to insulate the judiciary from all aspects of public accountability. Kind of seems like it. Such as the normal obligation to respond as a witness when he has information material to a criminal or civil proceeding. Citing U.S. Nixon, 1974, it explained that the court's concerns underpinning the concept of judicial immunity, a judge's independence and judicial performance, are not similarly found when a judge is required to testify against co-conspirators, noting that a proceeding in which he cannot be held liable in which he need not defend is not of the same order of magnitude as the prospects of being a defendant in damages action from complaint to verdict. I don't know. If I were those co-conspirators, I'd be pretty effing pissed if he got away with everything and he had to fight against me. I'd be really, really, really I'd be really pissed. Yeah. When you consider the bar in each state is policed by lawyers, it's like letting the inmates run the asylum. And it's one of the reasons that I hold judges, like, I don't like judicial immunity and I hate judges. The reasons I'm so hard on prosecution, because on the end of the day, the judge and the prosecutors are both actors of the state. So they both need to be held journey. In Forrester v. White, 1988, the court again was tasked with determining what constitutes. Hold on one second. Court again was tasked with determining what constitutes immunity purposes. Under Illinois law, circuit court judge has the authority to hire adult probation officers who were removable at his discretion. It's always Illinois. Damn fibs. Judge White hired Cynthia Forrester as an adult and juvenile probation officer. Judge White subsequently demoted Forrester, then terminated her employment, which Forrester was alleged was an act of discrimination based on her sex in violation of the Equal Protection Clause of the 14th Amendment. After a jury granted an award in Forrester's favor, Judge White moved for a new trial, which was granted, and then moved for summary judgment on the grounds that he was entitled to judicial immunity from civil damages suit. Ain't nobody want to see that. Oh. It might make a good YouTube channel, though. Oh. I'd be like Judge Janine. Not nice. Both the district court and the Court of Appeals agreed that Judge White was immune from damages. The Supreme Court reversed. In so doing, it noted that running through our cases with fair consistency is a functional approach to immunity questions. in which the court examines the nature of the functions with which a particular official or class of officials has been lawfully entrusted, and seeks to evaluate the effect that the exposure to particular forms of liability would likely have on the appropriate exercise of those functions. The court stated that difficulties draw a line between truly judicial acts for which immunity is appropriate and acts that have simply happened to have been done by a judge. And I think this act is just an act that was done by a judge. I would move just to sit in her courtroom. Yeah, I don't think anybody would. Yeah, that would never happen. The court reiterated that immunity is justified and defined by the functions it protects and serves, not by the person to whom it attaches. But also noted that the court has never undertaken to articulate a precise and general definition of the class of acts entitled to immunity. The court found, however, that the case suggests an intelligible distinction between judicial acts and the administrative, legislative, or executive functions that judges may on occasion be assigned by law to perform. Thus, the court found that judicial immunity did not apply to acts such as this is another word that, like, my brain knows how to say it, but my lips just can't figure it out. Promulgating a code of conduct for attorneys, which is not an adjudication, but one of rulemaking. It concluded that in this case, Judge White was acting in an administrative capacity when he demoted and discharged Forrester. The court stated that while those acts may be quite important in providing the necessary conditions of a sound adjudicative system, the decisions at issue, however, were not themselves judicial or adjudicative. The court stated that absolute immunity is strong medicine justified only when the danger of officials being deflected from the effective performance of their duties is very great. This statement makes me think that she's not the judicial immunity is not going to fly. No. No. Only if you consider, like, Judge Simpson's people that watch his YouTube channel every day and never miss a video or a live stream, stalkers. It's not like you moved across the street from me. Just saying. Sorry. I couldn't help but drop that little tidbit in there. It fit so perfectly. And in this case, the danger was not great enough. The court further found that it was not significant that under Illinois law, only a judge could hire or fire probation officers, finding that to conclude that because a judge acts within a scope of his authority, such employment decisions are brought within the court's jurisdiction or converted into judicial acts, would lift form above substance. Thus, the court concluded that Judge White was not entitled to absolute immunity for the decision to demote and discharge Forrester. I mean, just because I watch a video doesn't make me a stalker. Oh, I love Judge Simpson. He is hilarious. Okay, you're good. And Jinx, stalker fun. Thank you for the 17. I couldn't even begin to tell you what form of currency that is, and yes. And if you are the praying type, I continue to say this every time I see Roy in chat during a live stream, but his wife, his wife, obviously more than him, but could definitely use your prayers. She is going through a hard time right now, medically speaking, and they need all the prayers. Things are going about as good as they can be. Yes, Gail, we got some good news yesterday. Things are going about as good as they can be from what I hear. But never, just because things are looking up doesn't mean we stop caring or praying. Danish kroner. Thank you. Thank you. Jinx and Baker from the same area. Thank you. Hey, LRG. It's one of those things that you think you know the answer, but then you also don't want to look like completely inept and stupid and say it and be wrong. So I just don't say it. I just admit when I don't know something and move on from there. And Jinx, I'm pretty sure you've told me that multiple times, and you see how I remember. So, all right. Come here. Come here. Hold on 1 second. Sorry, you're going to see my fat butt. Hey, give me a napkin for you, boo. You kept throwing it at me. Play some good music. Don't get me a copyright struck, though. Alrighty. 3 years later, in Morales v. Waco, 1991, the court again considered whether a judge acted within his jurisdiction and whether the alleged conduct was a judicial act. The plaintiff was a public defender who was scheduled to appear before the judge. After counsel failed to appear, the judge allegedly ordered law enforcement to forcibly and with excessive force seize and bring the attorney to the courtroom. The court stated that case law makes it clear that immunity is overcome in only two sets of circumstances: actions not taken in the judge's judicial capacity and actions taken in the complete absence of all jurisdiction. As to the first circumstance, in determining whether an act falls within the judge's judicial capacity, the court clarified that the relevant inquiry must be the nature and function of the act rather than the act itself. In other words, one must look to the particular act's relation to the general function normally performed by a judge. I mean, she likes to play music. So I have the Apple Music family plan, and since she has on her phone, she has access to YouTube Kids and Apple Music and FaceTime of her grandparents. And I have she likes to play, she'll sometimes run the workout music. And since it's loud, I just don't want her to get me copyright struck by some music. So I don't want her to get me copyright struck. Hey, Alita. How are you today? For instance, in this case, the judge's direction to the court's officers to bring a person who's in the courthouse before him is a function normally performed by a judge. However, a judge's direction to carry out a judicial order with excessive force is not. The court concluded, however, that it cannot scrutinize only the particular act in question, because any mistake of a judge in excess of his authority would become non-judicial and is no improper act normally performed by a judge. The court further explained that because judicial immunity is immunity from suit, not just from damages, judicial immunity is not overcome by allegations of bad faith or malice. It's that malice that I just can't get over. So that anything that a judge does is malicious, you automatically should lose your judicial immunity. It should not even be a question. Like it. A spawn trooper will be on here and she will say, "Just a second," like she did with Baby Squid. He stops mid-sentence every time. So Spawn and I were actually talking about that today. He doesn't talk much when he's on my channel. Surprise, and the thing is he doesn't interrupt me. He never interrupts me. I interrupt him constantly. And it's funny because I still get the occasional, you look so mad when he interrupts you. It's like, how many times a day he has to tell me to shut the F up because I'm talking and I interrupt him constantly. And he says it in jest and will you let me talk, lady? Kind of situation. It's kind of like when Captain Kern was in here and I called him a butthead and he called me one back. It's like we're friends. Like we don't get offended by it. Like, you know, he'll tell me the shut the F up and I'll call him a wealth twat. Then we'll just move on with our day. It's hilarious. Which ordinarily cannot be resolved without discovery and trial. You rang? Just using you as an example of, how I communicate with my friends. How we call each other buttheads and, tell people to shut the F up. And you know what? We just laugh and we go, shut up and move on. As to the second circumstance, the court concluded that if the judge authorized and ratified the police officer's use of excessive force, he acted in excess of his authority. However, such an action, taken in the very aid of the judge's jurisdiction over a matter before him, cannot be said to have been taken in the absence of jurisdiction. Thus, the court found the judge immune. In sum, the doctrine that a judge enjoys absolute immunity from civil lawsuits or monetary damages when engaging in judicial acts is solidly established. But see Pulliam v. Allen, 1984, concluding that judicial immunity is not barred to prospective injunction relief against a judicial officer acting in her judicial capacity under 1983, nor does it bar an award of attorney's fees under 1988. This, however, all of that for this sentence, she could have summed this up. Like, I appreciate the education, Miss Nancy. However, that whole 10 pages could have been summed up with this. This, however, is not a civil suit. Dugan has been criminally charged under federal statute. Thus, the question is whether the clearly established principles governing judicial immunity in civil lawsuits applies to the criminal prosecution of judges. All of that 10 pages. I appreciate the education, but damn. It's hey 81. Good afternoon, 82. Just catching up at 1, 2, 3. Hi, can I see that? 1, 2, 3, go. Okay, and that's why I love this channel. Yeah, and it's funny. The people that get offended by it is like it's like, tell me you either 1, weren't in the military, or 2, don't have super close friends that you can like say whatever you want and they'll just laugh at you. And just, yeah, Judge Grudge is screwed. Yeah, this is not this particular case. This is Judge Dugan. This is from Milwaukee. This is a judge that if I ever got in trouble that I might have ended up in front of. So this is one of the other reasons that it's this is the judge that I might have had a run-in with. I'm offended, but I'm not sure why. It's one of those things, like, I'm offended by like boy bands, but you didn't see me like getting all up in arms whenever they go on tour, do you? All right. All of that for one paragraph. Oh, here we go. And I think we're gonna she's good. Bye. See you. Judicial immunity from criminal prosecution. As discussed above, Floyd was a criminal case. Thus, the first mention of judicial immunity in the context of a criminal case goes back to Floyd. As cited above, Supreme Court's first major application of judicial immunity was in 2 post-Civil War era cases, Randall v. Brigham and Bradley v. Fisher. And as authority for judicial immunity in the civil context, the Randall v. Bradley courts invoked Floyd. However, although the Supreme Court looked to Lord Coke's pronouncements at starting point for judicial immunity in civil cases, in the 154 years since Bradley was decided, Dugan does not cite. Damn! I need that what is it, Friday, or is it Friday after next, where they go, damn, I need that soundbite, because it's a girl. It's Judge Hannah Dugan. Yeah, it's Dugan does not cite, and I have not found cases where the Supreme Court invoked Floyd for the. You're happy? For the proposition that judicial immunity, we're still working out the toddler speak and what we're actually trying to say. Oh, I completely agree. I completely agree. And there's cases where people just generally make mistakes, and like nothing was actually intentional. And sometimes it's like you make a mistake. There are certain things where I can see some judicial immunity being, but other times it's like, nope. Ugh. All right. The most we have gleaned from the Supreme Court about judicial immunity in the context of criminal cases have been in reference to 18 U.S. Code 242, which is not charged in this case. Section 242, the criminal analog to 42 U.S. Code 1983, allows for criminal prosecution for the deprivation of constitutional rights while acting under color of state law. This criminal statute was passed as Section 2 of the Civil Rights Act of 1866. See Harvard Law Review at 1467. Although the language of the statute itself does not address its applicability to judges, the legislative history of the bill is clear that its applicability to state actors, including judges. Do you want to show everybody what you do? Mm-hmm. She takes this and puts it over her head. So it's she turns 3 at the end of the month. So we almost have a 3-year-old on our hands. Yeah, we do. Girl, your hair is a hot mess and a half. Ugh. Between the humidity and her putting that rag over her head and then her spilling a popsicle and on her hands and rub it in her hair, we need a bath. There are sometimes I can understand her, and there are sometimes. Me too. Hey, Dan. Thank you. Washing your hands? Girl. Water? My water. Okay. Including judges, was of expressed concern to the drafters. In fact, in vetoing the bill, President Andrew Johnson was concerned that Section 2 would subject judges to criminal prosecution if they render judgments in antagonism with its terms, asserting that the provision invades the judicial power of the state. The 39th Congress, first section, 1688 or 1866. She actually provides the link. Last visited July 7th, 2025. Upon reconsidering the bill after veto, the bill's sponsor, Senator Lyman Trimble, responded that a judge, if he acts corruptly or viciously in the execution or under a color of an illegal act, may be and ought to be punished. I don't see how that is controversial these days. But if he acted innocently, the judge would not be punished. Like right there. If it was an innocent mistake, sometimes people just make mistakes. Things happen. Yeah, but if you corruptly or viciously or maliciously, similarly, Representative William Lawrence of Ohio stated that, quote, it's better to invade the judicial power of the state than permit it to invade, strike down, and destroy the civil rights of citizens. A judicial power perverted to such usage should be speedily invaded. Subsequent to the Act's passage, the Supreme Court upheld a judge's prosecution for a constitutional violation in Ex parte Virginia, 1880. In this case, a state court judge was criminally charged for excluding black jurors from a jury selection in violation of the 13th and 14th Amendments. And 1880. We're 15 years post the end of the Civil War. Like, stop being stupid. In Virginia, at that, like, the judge argued that Congress could not punish a state judge for his official acts, and by selecting a jury, he was performing an official judicial act. The court disagreed, stating that the duty of selecting jurors is a ministerial act. However, even if the act was judicial, the judge had no authority to select jurors in violation of the Constitution. Approximately 100 years later, while addressing judicial immunity in the civil context of 1983, the court invoked the threat of judicial prosecution under 242 in response to arguments that civil immunity provide no recourse against corrupt judges. See O'Shea v. Littleton, 1974. On the contrary, the judicially fashioned doctrine of official immunity does not reach so far as to immunize criminal conduct prescribed by an act of Congress. Imbler v. Patchman, 1976. Even judges cloaked with absolute civil immunity for centuries could be punished criminally for willful deprivations of constitutional rights on the strength of 18 U.S. Code 242, the criminal analog of 1983. Dennis, 449 U.S. at 31, but judicial immunity was not designated to insulate the judiciary from all aspects of public accountability. Judges are immune from 1983 damages actions, but they are subject to criminal prosecutions and as are other citizens. In sum, although the 17th century English case of Floyd declared judges immune from criminal prosecution for judicial acts, the Supreme Court has only cited Floyd in civil cases for the proposition that judges are immune for purposes of civil damages, the only context which the Supreme Court has spoken on judicial immunity from a criminal prosecution regarding 242, and the court found that judges are not immune from criminal prosecution under the statute. Yeah, it was only 15 years, but like it's kind of one of those things of like the amendments. When were the 13th and 14th Amendments passed? 1866? I'd have to Google it. However, like there's a difference between what you think personally and what should be your, but also you thought you do with it because of judicial immunity, and obviously that didn't happen. So yeah, not surprised something like that happened at the time. In a way, I get it, but there's a difference between like what I personally think about. So like random person on the street, there'd be a personal difference between what I think about a person. Like I had a person walk in front of my car today, and expect me to stop. No crosswalk, just randomly like started walking across the street. I'm doing 35 miles an hour, stuck their arm out and pointed their finger at me like, what drugs are you on, dude? There's a difference between what you think and what you do. What I thought was I'm just gonna hit this mofo because he walked out in front of my car. What I did was not do that. So like I get that the mindset takes decades to change, but there's a difference between what I begrudgingly want to do or want to say, and there's then what I actually do as a law-abiding citizen. Like, you know, he walked out in front of my car. I really wanted to just run the mofo over, but I didn't. So, like, I understand where you're coming from. I really do. It was definitely right for the judge to get punished. Yes. It's just one of those things. I understand that the mindset takes, but as an adult, a functioning adult, there's always a difference between what you want to do. Like, sometimes I wake up and I don't want to do anything. Like, I didn't want to go live today. I didn't want to go to the gym today. I didn't even want to make breakfast this morning. But being an adult, there are just certain things that I have to do and I need to do. And like, kind of like I understand it, but in a way I don't understand it because I guess I just don't have reality. So, and it's also 150 years later. So you need a squid sleep day. What is that? I went to sleep at like 1 o'clock this morning. And baby squid got up at 6. So we running on low sleep and actually low caffeine. And I think this is actually Dugan's arguments is where I'm going to call it a day on page 15. We're about halfway through. Because I need to get, and then it goes, the judge keeps on going. So we will hit this up probably either tomorrow afternoon or Saturday to finish this up. I personally feel the judicial system in the United States and that judges have immunity, can go above and beyond the law. I wish that, yeah, and I'm really hoping that cases like this are where new case law can, new case law can take in. And that's one of the things that, like, yeah, I cover some difficult cases as far as like parents and children and stuff like that. However, the cases that I enjoy covering, like the documents in the Hales case, that I am hoping will have an impact on cyber harassment, cyberbullying, and how YouTubers are taken more seriously in the judicial system. And this case where I hate judicial immunity, it's one of like the things that irks me the most in our judicial system, that this can start to change, and this case will be used as precedent for future cases of judges not being immune for shitty behavior. And you can't claim judicial immunity. Like, asshole is not a protected class. Like, just because you're a judge doesn't mean you can break the law and get away with it. So I'm really hoping that this case changes that. And what's one of the reasons that it's fascinating to me. Other than that, it's my home state and my hometown. Like, Milwaukee is where I lived before I moved down here. So it's my home. So, all right, guys, this is where we are going to call it a day. We are on page 15. We're bottom of page 15. We will hit this up the next time. I have to go make sure that I have 2.5 loads of laundry left to fold. So I got stuff to do. Yep. I'm originally from Waukesha. I graduated from high school in Waukesha County. So, yep. I moved all over the Midwest as a kid, but most of my family is still from Wisconsin. And when I got out of the military, that's where I moved back to. So, and I lived there until 2020. So, nice. We're practically neighbors. Bye, everyone. Love this chat. Yes, goodbye to the best chat. I gotta say, y'all are the best chat on the internet. I swear. I can't even like. Oh, and I did actually. Yeah, I am from Waukesha, but I was born in Waukesha County. But that's but just because I was born there doesn't mean that's where I live all the time. I moved out of there when I was 18 and never moved back to Waukesha County. I'm going to see where I can. And thank you to all of the likes that we got. Let's see. We have 61 likes and 1 dislike. Thanks to my hater. Yeah. They think they're affecting me and they literally just make me laugh. Because they don't realize that hitting the down button like still helps with the algorithm. So I am going, guess who is able to redirect? So we're going to go watch Spawn Trooper go game. You're here just in time for us to say goodbye. But we're going to go over to Spawn. Yeah, 62 now because I forgot. And I'm so bad at that. So the people that call me grifter, I'm like, y'all are funny. Y'all are funny because I'm like literally so bad at it. Gail has to do it for me. That's what I have great mods for. All right, guys. I will talk to you guys later. Yeah, see? JKD Buck dropping the merch store link. Ta-ta for now. Bye, guys. I will see you. Do you want to say goodbye? Can you hear her? She said bye to y'all. Y'all have a great day, and I will see you guys on the next one.